I'll be discussing a crucial aspect of the immigration process. It's the procedural fairness letter. Although we all hope for the best when applying for immigration, we may get bumps along the way. A major bump is the procedural fairness letter. Canadian immigration is deeply rooted in the principles of natural justice and procedural fairness, and these principles guide immigration officers in specific cases to issue procedural fairness letters. This means that if an officer intends to refuse your application, they must give you one last chance to address their concerns. This final opportunity typically comes in the form of a letter or an email, depending on the circumstances. The officer will outline their concerns about your case and give you a limited time to respond, usually around 30 days, but it could also be as few as 7 or 10 days. If you receive a procedural fairness letter, do not waste time and consult with an immigration professional before responding. Avoid hastily responding to the officer, as a well thought out response is crucial to improving the outcome of your case. When addressing the officer's concerns, ensure you provide a comprehensive explanation and proper supporting documentation. It is strongly recommended to seek legal advice in this situation. You can contact our representative for help and ensure you receive the best possible advice and support. A procedural fairness letter is not always given in all immigration cases, particularly for temporary resident visa applications, such as visitor visas, work permits, or study permits. If you need assistance with a visa refusal or you believe you were unfairly refused, please reach out to us via email or call, and we'll do our best to help. Before diving deeper into the topic of the procedural fairness letter in Canadian immigration, please subscribe to our channel and hit the bell icon to receive notifications when a new video is posted. Procedural fairness is a set of guidelines that immigration officers must follow when making significant decisions that could negatively impact applicants. These guidelines stem from a landmark decision by the Supreme Court of Canada called Baker versus Canada. As an applicant, it's your responsibility to submit a complete, open, honest, and transparent application. Officers may request additional documentations or interview if they suspect misrepresentation, inadmissibility, or any other issues. In such cases, they will often send a procedural fairness letter, or most commonly known as PFL, to address these concerns. If you receive a PFL, it is crucial to assess the situation and determine the best course of action. This may involve presenting additional documentation to refute the officer's concerns or admitting any mistake and demonstrating remorse. I'll give you an example of a case where you just have to admit your mistake and demonstrate remorse. We had a case of a client who had some proof of funds in support of their permanent resident application, but when asked for an updated proof of fund documents, the applicant had moved some money out and back into the account. And if she just responded to that PFL letter without properly addressing why the money went out and came back into our account, that application may have been refused. In the case of another applicant who had contacted us, he had forgotten to mention some refusals. The applicant had simply forgotten to declare his UK and US refusals, even though he declared his Canadian refusals. In that case, he got a PFL letter stating that he could be slammed with misrepresentation, which would attract a 5-year ban if he didn't respond adequately to their concern. So in that case, we had to help him put together the response to the procedural fairness letter, basically admitting he's wrong. And we had to put some case law showing some other cases where the government has ruled that as long as the applicant declared some other refusals, it wasn't intentional to not disclose the ones that were in question. Another interesting case of PFL that we had is that of a permanent resident applicant whose company was located in the same building as a hotel. And the most common resource that visa officers would have is to go online and check any address or check any facts that you have in your application. And once they found that the address was that of a hotel, they had their concerns. And we just had to simply show different evidences, supporting documents, why the business is located in that same building as the hotel. These get quite interesting because the quality of the response to that PFL could make or mar that application. In these complex situations, though they may seem simple, it's in your best interest to consult with a professional who is experienced in handling PFLs, such as a licensed immigration consultant or lawyer, allowed to represent you legally. Tight deadlines may accompany PFL, so it is essential to communicate with the officer if you need further clarification or even an extension of time. You may also request an ATIP, access to information and privacy, to obtain your GCMS note. That's the Global Case Management System records, which has the officer's note. These can provide valuable insights into your case. Keep in mind that a PFL is a serious matter that could affect your future applications and interactions with immigration authorities. So, better do it right. Thank you for watching this video. If you found it helpful, please like, share, and subscribe to our channel for more valuable information on Canada immigration. And don't forget to enable notifications to stay updated on our latest content. See you next time.